Hello, and welcome to Ipsa Dixit. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest today is Deidré Keller, Associate Dean for Academic Affairs and Professor of Law at Ohio Northern University Pettit College of Law. We will discuss her current project, Will I Be the Next Hashtag, Black Death Spectacle or Catalyst for Change. So welcome to the podcast, Deidré.
Thank you for having me, Brian. I'm
the
excited.
Pleasure's all mine. Yeah, I'm sorry we weren't able to record you while you were in Lexington, but I'm glad I was able to get you on the podcast remotely. So I read your abstract and found it really fascinating, and I'm really looking forward to hearing more about the project. And I was wondering maybe if you could start off by just kind of familiarizing listeners with the two stories that you include in your abstract itself. So you talk about both Jordan Edwards and Emmett Till. And I was wondering if you could tell our listeners who those people are and how they fit into the project that you're working on.
Sure, absolutely. So Jordan Edwards, the more recent figure, Jordan Edwards was killed by Balch Springs police officer in April of 2017. He was 15 years old, and he was killed when the car that he was driving in, the officer shot into the car. A number of other teenagers were in the car with him. The officers, including his brother, the officers had been called to the scene for a report of underage drinking. And initially, the report out of the police out of Balch Springs police was that the car was advancing towards the officer, and that's why he shot into the car. But there was video footage to the contrary, and pretty soon after Jordan was killed, the Balch Springs police had to walk that back. And ultimately, the officer who killed him was arrested and charged with murder. So that is the Jordan Edwards. Those are the facts around Jordan Edwards.
Right. So a really sad and sadly all too common these days story.
Yeah. And Emmett Till was also, I think Emmett Till was 15 at the time that he died. He's definitely a young teenager. He was growing up in Chicago. His mother sent him home to Mississippi for where her family was from for the summer. And so he was home with family. And the allegation was that he whistled at a white woman. Her husband and other members of her family showed up at his family's house, drug him out of the house, and killed him. This was in the 1950s, and Emmett Till's mother, Mamie Till, made the decision to have her son's casket be open at his funeral. And she invited members of the press, especially the black press, to come take pictures. And so the pictures of Emmett Till's badly mangled body are pervasive and are credited with being part of what was motivating in terms of people starting off the civil rights movement. So
Right.
those are the two figures. They came together for me because I had been thinking about the intersections of intellectual property and privacy when Jordan Edwards was killed. So I have that paper, Copyright to the Rescue, at the UCLA Journal of Law and Technology. And so I had been thinking about how copyright intersects with privacy, how privacy and the right of publicity are related to each other. I'd been thinking about those questions. And then Jordan Edwards was killed, and pretty immediately after that, his family said that they did not want his name hashtagged, right? So in the months before that, really the years before that, lots of other folks killed by police or in encounters with police or even with what I'll call vigilantes had been, so hashtag Trayvon Martin, hashtag Jordan Davis, Sandra Bland, right? A number of other folks had been sort of on social media. The movement, the Black Lives Matter movement, was sort of using their names to make the case, right, for more attention to be paid to these issues. And his family said pretty quickly, we don't want to martyr our son. And so my brain said, well, what do families do? What could a family do in a scenario like that, where they don't want their now dead child's name or image used, right, without their permission? And of course, the tools that we have at our disposal are the right to privacy as lawyers and right of publicity. And so that got me thinking about whether those tools could actually be effective in a scenario like that. Emmett Till then came back into my thinking about this question because Dana Schutz, a painting by Dana Schutz was hanging at the Whitney. And the subject matter of the painting was one of those really iconic images of Emmett Till's badly mangled body. And at the time that the Whitney was displaying that painting, a Black artist showed up to protest against the display of the painting. And so that's actually where the Black Death spectacle comes from in the title. The artist protesting made the argument that Dana Schutz's representation of Till and the Whitney's display of it was making a spectacle of Black Death. And so that made me think again about this idea of sort of unauthorized uses of the names and likenesses of folks killed, especially Black children killed by police or, in Emmett Till's case, by vigilantes. And so the Dana Schutz protest had me thinking about the same questions, right? Are the right of publicity, the right to privacy, are they up to protecting against those kinds of unauthorized uses? Which is really sort of a doctrinal question, right? So that's the road that I went down first, the doctrinal road. But I then started working on an edited collection out of a conference that I did, that I put together with Anjali Vats and Jessica Silby and Emmett Till at Boston College in April of 2017, which was about race and IP, right? So sort of bringing critical race theory to bear on intellectual property questions in a way that hasn't really been done substantively. And so that's sort of how I ended up at asking the more normative question, right? Should that kind of protection exist?
Right.
Sort of where this paper is. This piece is at the normative side of the question, right? Should we protect the privacy of families who find themselves in these really difficult circumstances of having lost a child?
Yeah. No, and I think that should question is really important because at the end of the day, it's what really matters, right? I mean, what's really at stake here is, how should we as a society think about people's feelings and experiences in these kinds of contexts. And, that seems like it's not an easy question to answer.
Right. So the mom in me is like, absolutely, we should, right? The fact of the matter is that I'm the mother of 5 boys and Black boys. And so this is close to home in that sense. And of course I would want privacy if my child were killed in some violent way, right? The flip side of that is that there is lots of good historical work around the effectiveness of those Emmett Till photographs, right? And the other photographs and imagery that came out of the civil rights movement. We can all think of those pictures of dogs attacking protesters and the police spraying protesters with fire hoses, right? Those images are iconic because they really were effective and utilized strategically by the movement to change the narrative, right, around racial justice. And so I see that side of it as well. And so the project in the book chapter is to think through those sort of competing interests and try to come up with an answer to that should question.
Yeah. Yeah. I mean, it really does seem like you've got this question of whether people should be able to prevent the symbolic use of a murdered person, even if that use may have positive social effect. And then it seems like the Dana Schutz situation that you mentioned introduces kind of a parallel question, which is like, who should be able to prevent, or who should have the sort of social right to object to particular kinds of uses?
Right. Yeah. So in the Jordan Edwards case, it's really simple, right? It's pretty straightforward. It's his family. If anyone has that right, it's his family, right? His parents, if you will. And there's some really, there are some easy parallels there around privacy and parenting, right? And so there are some easy legal parallels that we can draw. The Dana Schutz question is much more complicated because the protest was not by specifically Emmett Till's family, right? Although I will say that I'm aware of the fact that, for example, the Emmett Till display at the Smithsonian, at the African American Museum, you cannot take pictures there. It's one of the only places in the museum that you can't take pictures. And my sense is that actually is in respect for the wishes of his family. So I think that it's not clear to me that Emmett Till's family, the remaining members of his family, are not troubled by or would not like some ability to control the uses of his image and the like.
Do you have any sense about how the members of Emmett Till's family, other than his mother, felt about that in the moment?
I don't. There's so much interesting writing about Mamie Till and her decision. I mean, she's really sort of lauded for that decision, right?
Yeah.
And I get that, but I also, I mean, it was a hugely important moment. But at the same time, one wonders whether, had she chosen the opposite tact, right, whether that had been a respected choice. And the question there for me is a question about sort of, the norms around grieving, for example, right? So even very famous people who, when they have sick children or their child is killed or dies even, we as a society sort of grant that is a private moment, even if you're someone who has opted to be in the public eye. And of course, these families are not opting to be in the public eye, right? They're sort of thrust there, and then they have to deal with it. And so, to me, the question is, some of us are not Mamie Till, and we should get to be not Mamie Till, right? And so sort of the counterexample to Jordan Edwards for me is Jordan Davis, who, do you know the Jordan Davis story?
No,
okay, so Jordan Davis was killed in Florida because, he was at a gas station and someone told him that he was playing his music, that they were playing their music too loud. He was with a bunch of other teenagers.
Right.
So he shot into the car, killed Jordan Davis. And his mother, Jordan Davis's mother, is now Congresswoman-elect in Georgia. So, she has been very publicly out. Her sort of signature issue is gun reform, gun control. And so she just won in Georgia on a gun control platform. So that's right. That's no small feat. And so I say that to say we have a number of examples, right, of mothers of Black boys killed doing something with that politically. And I think that's all fine. The question is, can you make the other choice, right? Is it allowable? Is there space?
Yeah. Well, from a doctrinal standpoint, I mean, it's not really my area per se, but it seems like the right to privacy would be the most kind of obvious route, but it seems like there are potential problems there insofar as these murders are so public and so newsworthy. Do you think that the right to privacy as it stands is up to the task, or do we need to think more or differently about how the right to privacy should work in a sort of social media connected hashtag world?
So I don't think the right to privacy is up to the task, because before we even get to the question of newsworthiness, we have to deal with the fact that the right to privacy has, by and large, been denied to people who are deceased. So,
of course.
So once you are deceased, you have no right to privacy, which is really interesting, right? When you think about this is why folks use copyright to get around that problem, right? So when you think about oh gosh, I'm trying to think of the famous author whose estate has blocked the use of his letter. No, not Salinger.
You're thinking of?
Oh, it's going to come to me. But so so what estates do is they use copyright to get around it, right? And they say, oh, there's a copyright in these letters between, our father and our sister. And so you can't write. You can't make reference to the letters. They don't really care about the copyright. They care about the privacy, right? And so, So no, privacy won't get us there. The right to privacy won't get us there, which is what got me marching down the right of publicity road, because the right of publicity does, in many places, continue after death. So now that's not true in New York, although there is a continuous push to fix that in New York. But in most places, in California, certainly in Georgia, the right to privacy or the right of publicity is recognized as existing after there's a postmortem right, in other words. And so that's what got me sort of moving in that direction and thinking about the salience of the right of publicity doctrine for this. You run into the same newsworthiness problem, right? So, and then what do you do with that?
Right. Well, it also seems like there's sort of a normative or structural tension in thinking about the right to publicity in those terms, because it's, well, at least typically conceptualized in such sort of economic sort of internalizing positive externalities sort of way. And that's just really 180 degrees from what's going on here.
The upside is that the right to privacy and the right of publicity are really sort of historically deeply connected, right? So if you go back to where the right to privacy came from, I don't mean normatively, I mean in our law, right? Where did it come from? There's that 1890 Warren and Brandeis Law Review article, Harvard Law Journal, in which they make the argument that we should recognize a standalone right to privacy, right? But at the time that they made that argument, literally no court of last instance had ever done that. Ever. So they make the argument, and then it's 15 years before a court of last instance does it. And it's in a case called Pettit. And what's interesting about that case is today we would call that a right of publicity case. So it's a case about the use of a photograph in connection with an advertisement for insurance. So, skip forward, 100 years or 120 years, and you wouldn't make that claim as a right to privacy claim anymore, right? You would make it as a right of publicity claim today. But at the time, that's how deeply connected these things were, right? The first statute protecting the right to privacy, which is the New York statute, which remains pretty much the statute that was adopted in the early 20th century, that also has ingrained in it a misappropriation claim, what we would today call a right of publicity, right? So these things are not that distinct from each other, at least as a historical matter. And so that's why you'll see the right of publicity sort of embedded in privacy statutes in various places, like here in Ohio. If you go look at our privacy statute here in Ohio, one of the things that you cannot do is misappropriate for commercial purposes. The name, likeness, that's right of publicity, right? So teasing them apart isn't all that simple, but you're absolutely right about the economic aspect of the right to publicity. And part of the tension there, part of the difficulty in deploying the right of publicity in the kinds of fact situations that concern me in this piece is that these families don't want money, right? They don't want to be compensated. That's not what they want. They want you to not use their family member's name or likeness, right? They want to have some control, in other words, over the use of their family member's name or likeness. And the right of publicity really doesn't usually do that, right? It doesn't usually allow for the kind of remedy that families like Jordan Edwards' family would want. And so that begs the question of, so if we leave to the side for the moment, should protection like this exist? We have to ask the question of, if it did exist, what would it look like, right? How do we model it?
Yeah. Well, I wonder, Deidré, I mean, do you think this kind of long-standing privacy publicity dialectic is the right way to think about the kind of social goals that we actually want to achieve? Or does the work you're doing now suggest maybe we ought to think about the whole problem differently?
Well, so that's interesting. That's an interesting question. How else might we think of this problem, right? What other kinds of causes of action could we imagine, right? So the is there a tort claim here? Is there some kind of property interest, right? Like, what is this thing? What doctrinal paradigm would exist to vindicate the kinds of harms that a grieving family might face if they don't have any control over the use of their deceased family member's name or image, right? I can't think of other mechanisms, right, that might be available to families like that.
Yeah. Yeah. I mean, I wonder if we don't need to think kind of in a new paradigm or think in a new way about what we want to achieve. I mean, because it seems like the sort of social circumstances and technologies of communication have radically changed who becomes a symbol in a way that can kind of grab and use people who wouldn't historically necessarily have been, in the position for that to have happened without someone like Emmett Till's mother, sort of choosing to make a symbol out of her son.
I thought about that, right? Because the difference between Mamie Till and Jordan Davis's family is actually really a simple one. And that is, it's actually sort of a property difference, right? The photographers that took the photos of Emmett Till had to be invited there by Mamie Till, right? And so to get access to Emmett Till's body, to the thing that became the symbol, they had to have her permission. They were effectively her licensees, right? The world has moved on from that because we have social media. But even on the access question, the world has moved on from that, right? Because how do these victims' names end up before the hashtag? How are they out in the public? Well, they're out in the public because the police makes a report, right? The Balch Springs police releases the name. And actually, very often, the police will release the name of the victim long before they release the name of the police officer who did the shooting, right?
Yeah.
And so what happens in the period between when the victim's name is released and when the shooter's name is released is that the media goes looking for whatever reason, justification might exist for the police to kill this person, right? And so that's why you see stories like, the way that Tamir Rice's mother was characterized in the media. She had a record and she was on public assistance, and none of these are justifications for shooting a 12-year-old child in a park, right? And yet, that's exactly what happened. And after Tamir Rice was killed, it was a while before we knew the name of the officer who killed him. And so, in this world where the information is being disseminated, right, widely, without any real controls by the family, it seems like we really do need to think a lot more deeply about how we might protect, where access was the protective mechanism, like just the reality of not having access 50 years ago, 60 years ago, right? So the one sort of analogous kind of law stuff that comes to mind is the way that we treat names of victims of sexual violence, right? So rape shield laws and the like.
Right.
And part of the reason that that comes to mind as a potential model for me is because the motivation for rape shield laws is not all that distinct, right, from my motivation for wanting some protection here, right? And that is exactly the same. I mean, before rape shield laws, the same kinds of narratives, right? Well, what did this person do? Where were you? Were you drinking? What were you wearing? Like all of those narratives were in the media, right? Around victims of sexual violence. And so there was a very similar sort of narrative trajectory, right? The name of the victim was released to the media, and the media went looking for justifications for why this particular person was the victim of sexual violence. That's a very similar kind of problem. And so I think that there's some analogies there, right? And so maybe the framework model for thinking about how the kind of protection I'm wishing for here might come about is to model on those kinds of rape shield.
Yeah. Well, at the very least, it seems like the private victim's privacy should receive at least as much protection as the police officers.
Exactly. But so the thing is that on the police officer side, they have a ton of protection, right? By way of not just by sort of what this is how we do things, but also like actual protection, so that very often their union contracts articulate specifically, right, what has to happen before their name is released in a shooting. You know what I mean? So there is protection. There's a reason that we hear the name of the victim way before we hear the name of the police officer. And that reason is that the police officer has, sort of private law protection, where you would think that should be exactly reversed, right? The private citizen should have some private law protection, certainly as much as the public servant.
Yeah. Well, so I imagine the primary pushback against this sort of new way of, or new approach or way of thinking about what the privacy of a victim or the victim's family ought to look like would be people raising like First Amendment type objections, which seem pretty unsatisfying to me, honestly. But I was wondering if you could talk a little bit about sort of how you would frame First Amendment values.
Yeah, so the First Amendment stuff is a quagmire for a number of reasons. For First Amendment purists will hate this. I mean, I just have to get sort of comfy with that idea. There's a book out recently that I'm not going to remember the author of now, that's called What's Wrong with the First Amendment? And it's about this, right? It's about this sort of notion that the First Amendment is sacrosanct. There are no limitations on it. Of course, we know that's not right. That can't be right, right? And so I would say that the First Amendment yields to all sorts of things all the time, right? The book is by Stephen Schifrin. So, yeah.
Right.
So the First Amendment yields to all sorts of things all the time, right? The First Amendment yields to copyright very often, as you know. And so, this notion that the First Amendment, we can't sort of and in fact, even in these scenarios, the First Amendment is yielding to the private law contractual, union rights of police officers, right? So even in this context, the First Amendment, there's give there, right? And so that's sort of my gut reaction to it. But even having said that, the relationship between privacy and the First Amendment is itself like deeply complicated, because of course we all know sort of the newsworthiness stuff, but privacy and the First Amendment intersect with and frustrate each other in lots of other ways as well. So there is, there's that line of cases about how you can't, let's say, go knock on someone's door and try to, if they ask you to leave, basically you have to leave, even if you have a political message, right? Mm-hmm. And that is, of course, privacy winning over the First Amendment, right? And it's not constitutional privacy, right? Because for constitutional privacy, we need some government, some state action. It's tort type privacy, right? Invasion of a private sphere. It's that kind of privacy. And yet, constitutional right, mm-hmm. the highest protection type constitutional right, First Amendment right, is yielding to privacy there, right? To tort type privacy. And that's really interesting. And the way that gets framed in the discourse, in the literature, is there is a constitutional aspect to that kind of privacy, right? And the constitutional aspect is, just as I have the right to speak, I have the right not to speak. And just as I have the right to listen, I have the right not to listen, mm-hmm. right? So I'm not necessarily convinced by that infusion of constitutional rhetoric, but I raise it to say that if we impose a privacy right here, despite the First Amendment, it won't be the first time that the First Amendment is yielding to privacy concerns, right? So the question is just whether there's a justification, right, to have the First Amendment yield to privacy concerns in this context, just as there is a justification to have the First Amendment yield to privacy concerns when I don't want to listen to, whoever's political speech on my doorstep, right?
Yeah. Yeah, no, that makes sense. I mean, the First Amendment isn't and shouldn't be just a trump card. It's, it is itself expressive of values. And it seems to me that you're really highlighting the fact that, when somebody asserts a First Amendment value, you have to put it up against the competing values that it's demanding should yield.
So interestingly, I think the First Amendment yields to copyright too often. Right. And so, I mean, I do. It's sort of absurd to me how much room we give copyright relative to First Amendment concerns. And I've written about that question as well. So I am for sure not saying in all instances the First Amendment should yield, right? I definitely think that it's exactly what you said. We have to always be doing this balancing, right? Of, okay, we have a First Amendment value at issue here. What is the competing concern? What is the competing value? And and I think I can make the argument that the competing value here is a dignity interest, right? In having the space to grieve in the way that the family sees fit. And so, I mean, I think that there's a good amount of there are good examples in our law for sort of respect for the dead and respect for people's grieving processes that I should be able to make that argument.
Yeah. Yeah. No, that sounds right to me as well. Well, Deidré, this has been a great conversation, and your project just sounds really fascinating and timely. And I look forward to reading it when you have a draft ready.
I will send it your way.
This is Dolan Ellis. I hope you've enjoyed sharing these songs with us. The folks at Western Savings sure have enjoyed preparing this special album just for you. And I guess that's because the people at Western not only appreciate having you for a customer, they also love this great state of Arizona as much as I do. You know, since 1929, Western Savings has been growing right along with this whole big state. And they realize what it means to be Arizona's largest savings and loan. For now, and until we meet again, adios.